Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be discussing the recently released study proving that reduced incarceration rates do not increase crime. We're going to catch up with the prosecution of a musician for the exercise of his First Amendment rights. And we're going to be looking at the investigation into a murder of an inmate in the Ohio Department of Rehabilitation and Corrections Correctional Reception Center. In segment 2, as promised, we're going to be talking about the similarities and differences between your Fifth and Sixth Amendment rights to counsel. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. So Erica, did you see in the news this week that the study was released showing in 2020, there was not an increase in overall crime rates, despite a decrease in the rates of incarceration?
I can't tell you how happy I am to hear that, because this is something that you've said all along. So can you remind us of the circumstances of this study? How did they perform it?
Data was collected from a cross-section of the country, specifically 11 jurisdictions, including major metropolitan areas in states like California, Washington, and Illinois, as well as smaller cities in Louisiana, South Dakota, Pennsylvania, and Missouri. The study looked at the data and found that from January of 2019 all the way through December of 2020, people who were released on pretrial release and the overall prioritization of arrests away from petty offenses and towards violent crime did not result in an increase in overall crime rates. Most jurisdictions had responded to the pandemic by reducing face-to-face contact between police and the people and reducing incarceration rates, both at a local jail level and on a statewide prison level. Probation check-ins were reduced. And what we found was that the number of alleged crimes happening and the number of probation violations being alleged in court didn't increase significantly at all.
I'm so happy to hear this. So can you tell us a little bit more about why these results are significant?
What the study shows is that despite the hand-wringing and fear mongering that a lot of politicians wanted to push, releasing inmates and the accused did not endanger the public. Reducing incarceration rates had very little impact on reported crime. It's important to note here that the results occurred at the same time as many jurisdictions saw an increase in homicide, but homicide is only one facet of crime as a whole. Critics also noted that the reduction in crime could be related to a reduction in crime reporting, as well as a consequence of the brutal loss of life that we suffered throughout the course of the pandemic. But what I think is most important about this study is that it joins a variety of evidence-based reporting that supports advocates and attorneys and gives them another tool to convince judges and prosecutors that pretrial release does not endanger the public. Low bonds must be connected to their actual purpose of making sure that an accused shows up for trial and maintaining an accused community connections as much as possible, allowing people to keep their jobs, their homes, and their children.
I think it's really wonderful. And I'm wondering, if they are not going to be incarcerating as many people, what are the options that courts have besides keeping the accused in custody to ensure that the public is safe while their trials are going on?
So instead of setting a cash bond that may keep somebody who's unable to pay it incarcerated, courts can set personal recognizance bonds that will result in a new arrest and new charges if the accused fails to appear. They can make continued employment a condition of bond to make sure that the accused has some stability in their lives and something to keep them out of trouble. They can reduce and waive fees and costs associated with global positioning tracking devices, secure continuous alcohol monitors, also known as SCRAM devices, so that if there are worries about dangers to the public from overconsumption of alcohol, from just even fleeing the jurisdiction or having contact with somebody that the accused isn't supposed to have contact, there are alternatives available to allay those concerns. And using those tools rather than just locking somebody up is both more cost effective and doesn't result in increased crime. And instead of jailing somebody or putting them into prison, judges can use house arrest with or without electronic monitoring as a consequence for antisocial behavior. They can suspend the jail time and hold that jail time over their heads under supervision. They can provide medical furloughs to allow hospitalization and relocation to supportive living condition situations so that people can get the treatment that they need. Using these alternatives to traditional incarceration, again, reduces cost, reduces the number of crimes that are committed in the community when the offender is re-released.
I'm sure they're going to have studies to show how this new way of doing things is going to work out in the future. And I'm really happy to hear that people aren't going to have their lives as negatively affected while they're waiting for trial. As we've talked about before, even from getting sick in jail, I mean, when the COVID situation was really running rampant last year, to lose, like you said, losing your family, your job, all of that will hopefully be avoided while people are going through their trials.
Well, yeah, and a certain percentage of these people will be completely acquitted and exonerated even after having their lives upended by being incarcerated. And an even larger percentage, a vast majority of cases, will have their charges reduced and probably to a point where they don't have to suffer additional incarceration. And cutting people off from their community, cutting people off from their employment for a period of weeks or months does not create a recipe for success once they're on community control or probation. Did you see, Erica, this week that Justin Coffman and his case were drastically gutted by the judge following a motion to suppress evidence?
Oh, I did. And this was such an interesting case from last year. Can you remind us of the circumstances of the prosecution of Justin Coffman?
Absolutely, Erica. Justin Coffman is the lead singer of Gunpowder Riot, and he posed in and created promotional images for his band right around the time of the civil unrest surrounding the murder of George Floyd. The images featured a fake Molotov cocktail and a banged up police car. Local law enforcement took that personally and targeted Mr. Coffman with warrants and police harassment, ultimately arresting him and charging him with possession of a hoax device for the apple juice Molotov cocktail and additional federal gun charges for being in possession of a firearm while also being a user of the devil's lettuce.
The devil's lettuce.
Marijuana, Erica.
I have
Marijuana.
not heard that. I have not heard that term before. Just goes to show what a good girl I am, apparently. The devil's lettuce. I love it. So not that any of this is funny though. What did the judge decide in this case?
So the affidavit that law enforcement filed and used to get a search warrant for Coffman's house failed to reference key information, such as the fact that Mr. Coffman is in a band, that the images were promotional materials, that they were staged and produced for the purpose of marketing the band. Now, when the judge reviewing that search warrant and the affidavit seeking it, took a look at it, he said there is no objectively reasonable belief based on the information that was known to the police at the time that there would be any evidence stemming from the search that was requested. And so all of the evidence that they seized was suppressed. It was excluded from use at Coffman's trial.
That is, it's incredibly interesting. So it sounds like the prosecution has no case. I mean, can they actually continue without evidence?
Federal prosecution is essentially over. While the case is still limping along for the government, the reality is the firearms, the evidence of the marijuana, Mr. Coffman's statements about using marijuana are all going to be excluded from trial. And I don't see how the federal prosecution can, in good conscience, continue. Could they still try and put on a case? Absolutely. Will they? I highly doubt it. Now, Mr. Coffman is also being prosecuted in state court, and the federal court ruling does not have any control over the state court judge. Now, Tennessee also has a law that provides an exception to the hoax device prohibition for dramatic purposes. And the fact that a federal judge has concluded that the images that support the state case were in fact protected speech will likely make that state court prosecution very difficult. Now there's case law on the exact issue, on this exact issue in their jurisdiction. So I think it's going to be really difficult for the state to continue prosecuting, but that case will continue to move forward.
I mean, just as an aside, I mean, did they bring up anything about the police harassing him or anything like that in the case? I mean, you may or may not know this. It sounded horrendous.
The ongoing harassment was not a grounds for excluding the evidence as raised by Mr. Coffman's attorneys. But I think the amount of media coverage, judges are people too. And, did this judge see what they were doing to him and why they were doing it? I don't know. What we do know from the motion to suppress evidence is that Mr. Coffman was clearly targeted. And I think the judge did take those arguments into consideration when making his ruling.
Thanks very much, Brian. That is very interesting.
So last but certainly not least, Erica, did you see in the news this week that there are now criminal charges against corrections officers related to the death of inmate Michael McDaniel in February of 2021?
I mean, that was a really sad case, and it's very interesting to see that they are getting punished for what they did. So if you can remind us, why was an investigation launched into the death of Michael McDaniel?
Corrections officers and corrections facility nurses collaborated and conspired to try and make it look like Mr. McDaniel had died from natural causes. The reality is he was beaten to death and suffered a heart attack as the result of that beating, which the coroner ultimately classified as a homicide. The investigation was then kicked off, and 10 corrections officers and 2 nurses have all been charged and participated in the cover-up of the assault and ultimately Mr. McDaniel's murder. 2 of the corrections officers have resigned. 8 others are on administrative leave while the investigation continues. Both nurses are under administrative leave, and the charges range everything from excessive and unjustified use of force, failure to perform duty, dereliction of duty, failing to provide medical assistance, and falsification of a document by a state employee.
I mean, I don't even know how this can even happen. It's unbelievable. It sounds like another movie script. Half the stuff we talk about sounds like it's unreal. So what changes has the ORDC implemented as a result of this horrible case?
First, and maybe most importantly for Mr. McDaniel, the blind spot that corrections officers drug him to beat him savagely has been eliminated. Other blind spots in the surveillance camera systems have been identified and also eliminated. Surveillance recording now saves for 45 days instead of 24 hours, and the corrections officers are being outfitted with body worn cameras.
Those sound like the right changes to make. I mean, would you suggest any others?
Well, the vetting of the officers is critically important at the higher stage. The reality is that an increased level of sociopathy is found in law enforcement in particular, and even more so in corrections officers. You know, the sort of masochistic mindset that gets pleasure out of seeing these people suffer in incarceration and bondage is very attractive to that kind of person. The unfortunate side effect of that is that they're violent towards the inmates. They don't look at them as real people. They look at them as some sort of object and use them for their own sick pleasure. So, you know, vetting people at the outset, critically important. You know, recording these conversations between nurses and corrections officers, I think, is going to be really important. Um, you know, so I think those are the two big things. Is, you know, we've got to do a better job of vetting law enforcement, and we've got to actually view these recordings and punish people who try to doctor the record, so to speak.
Yes, I agree. And I know we've talked about that thin blue line and keeping secrets and, really trying to work for a different environment where people feel safe coming forward and pointing out wrongs when they see them within the police force by other police officers. That would be great. Less fraternity, more civil servant would be an awesome thing to happen there. So, what do these changes mean to the inmates at the mercy of these corrections officers?
So the publicity surrounding this case and the efforts of the head of the Department of Rehabilitation and Corrections, Annette Chambers Smith, are a welcome change. You know, shining a light on this sort of behavior that has typically been hidden behind a wall of silence by corrections officers. Um, Now the public is aware. So, what is the biggest change for inmates? The public is going to believe you. Um, the addition of the body worn cameras, I think, is a good step, but it's misleading, as we have seen a variety of law enforcement turn their videos on and off at their convenience and in order to create a record that's favorable to them. I think the addition of the body worn cameras is a great protection for inmates, but it's not going far enough. Those videos have to be mandatory. Honestly, if law enforcement should not have the ability to turn them on and off. That should not be able to be controlled by the person wearing the camera. I think for inmates, it's important to know that this sort of abuse is going to be punished, that there is going to be consequences from it. But I also think, as far as corrections officers go, again, better vetting of these corrections officers, identifying and weeding out the sociopaths, and paying them better and training them properly to both improve their lives and their work, but also the lives of the inmates and the interactions, and making the interactions safe between inmates and corrections officers is the next step. It is a sad vindication for many inmates and their families who have suffered abuse in silence and without justice, only to see now the Department of Rehabilitation and Corrections finally admit that corrections officers do savagely beat human beings in their custody. And unfortunately, in this case, to the point that, Mr. McDaniel's heart gave out. And then all of that being covered up by nurses lying to protect their coworkers. It's some solace that there are consequences here, but it's not enough.
I mean, it's just like they're circumventing the entire justice system. And wielding their own brand of justice, which is completely the opposite thing that should be happening there. So I'm glad that some changes are happening. I'm glad that this is going to be part of case law and part of the news, and people know, what's really coming out there. And they have had to admit some pretty heinous mistakes.
Absolutely. And, accountability where it's appropriate is the way we move forward to both protect constitutional rights and make these dangerous jobs safer for the people that do them. Now, one of the protections that the Constitution gives us, Erica, is the right to an attorney. And it's in two places in the Constitution. There are key distinctions between your Fifth and Sixth Amendments rights, but both apply and give you the right to an attorney. Let's delve into the distinctions between your Fifth and Sixth Amendment rights to counsel.
This is really interesting because I don't know if I should be embarrassed to admit, I didn't realize that there were two parts of the Constitution that give you the right to counsel. And you hear about the Fifth all the time. Like you said, you hear, oh, I'm going to plead the Fifth. It's always in the movie scripts. It's always on TV. But I don't think people really understand it the way that you do. This is what you do for a living. So I guess let's start with a definition. What is the constitutional right to counsel?
So the Fifth Amendment guarantees protection from self-incrimination. And decades of case law have given us what we know as our Miranda rights. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and you have a right to have an attorney provided to you if you can't afford one. You have the right to not have, or that any of these statements that you might make will be used against you. Those warnings that people get read all the time on television and movies are pre-trial rights, pre-indictment rights. Now you keep them after you're charged, but they mostly apply before the formal charges are issued. The Sixth Amendment right to an attorney is not just about having an attorney before you're charged, but having an attorney, and a competent one, throughout all of the proceedings, from indictment all the way through sentencing. It also includes what we call the trial rights, the right to subpoena people to come in and testify for you, the right to confront and cross-examine witnesses that are testifying against you, the right to be informed of the charge that you are facing, and the right to have a speedy and public trial, and the right to have that trial conducted by a jury of your peers.
So, that makes a lot of sense. What would you say is the biggest difference between the Fifth and the Sixth Amendments right to counsel?
The simplest way to look at these distinctions is to call the Fifth Amendment your pretrial right to counsel, and the Sixth Amendment your trial right to counsel. The Fifth Amendment protects you from specific accusations. So if a police officer comes up and starts questioning you about a theft, and you say, I want to talk to my lawyer, the police officer can then start questioning you about, let's say, a murder. And you have to again assert your right to an attorney because it's allegation specific. Now, the Sixth Amendment right protects you after you've been charged and guarantees the right to competent counsel and all of those trial rights we discussed. And it guarantees in all of those moments that a knowledgeable and skilled attorney would be beneficial to the accused, that counsel will be there for the accused.
That's really interesting. Do you find that a lot of people that are charged with a crime or arrested don't really understand these particular rights and maybe say too much to the cops because they're an authority figure and they feel like they have to speak to the cops?
I do, Erica, and I think one of the fights that I push in courts pretty frequently is the the definition or the identification of the moment that a person is in custody for Miranda purposes. So your Fifth Amendment rights, you always have the right to remain silent, but you don't have to be warned, and your statements aren't excluded unless you're in custody. And as you were saying, Erica, people get really intimidated when they're around police. Now, what the case law says right now is that if an officer pulls you over in your car and he's standing right outside of your car window, you're not in custody. Your freedom of movement isn't restricted. And I think that's wrong. I think there are a variety of situations where people need to be warned and advised about their constitutional rights. And it needs to occur earlier in the police citizen interaction. So, to answer your question directly, Erica, no, people don't understand these rights. And I think police are those first responders, and they need to give accurate information, and they need to give it early in that interaction. The funny thing is that plenty of people still go and yammer away. So I don't think it's going to change the way law enforcement works significantly, but at least you're giving people the chance, and you're giving them the advice and the information they need to make an informed decision.
Yeah, I mean, I know when I used to go visit my ex-in-laws, they I just like them just being quiet. I felt nervous and I would just start talking. And I would tell them everything that I really didn't want to tell them sometimes just from them being silent and having, or they'll ask one question and they just weren't talkers. So I mean, you don't know what's going to happen in the interrogation room or even while they're being arrested. So it's hopefully, I mean, I can imagine it's a lot worse than my ex-in-laws. So why is the difference between these rights important?
These rights are not mutually exclusive. For example, you could get on the stand and testify at your trial, asserting your Sixth Amendment right, and having questions being asked by your attorney. So you're exercising your Sixth Amendment right to counsel and your trial rights, and then go and raise your Fifth Amendment rights against self-incrimination during the course of that testimony. Remember, it's charge specific, because the Fifth Amendment can come up in any sworn proceeding where statements are made under oath, including administrative proceedings and civil lawsuits. So these rights can be exercised at the same time, and the difference, and why the difference is important, is because we want to make sure that people are protected before they're accused, and that they get the fair shake that they're entitled to throughout the trial process. My advice is, whenever you're asked by law enforcement to make a statement, politely but firmly say, I have no comment until I speak to my lawyer.
And if you have trouble with that, practice before you get into trouble, because I can imagine those words are so hard to say to an authority figure. But Brian is right. That's really great advice. Thanks, Brian.
Absolutely, Erica. Thank you for joining me today. And to everybody out there listening, thank you for listening in and staying informed about the evidence-based practices that are being used in the criminal injustice system to make it a little bit more just. Holding police and government accountable, and learning the distinctions between your Fifth and Sixth Amendment rights. Look to the law office of brianjones.com. Find us on Facebook at facebook.com/Central Ohio Criminal Defense, and on Twitter, Instagram, and TikTok at TLOBJ. We'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of our Sixth Amendment right to a trial by jury. Erica, my grandfather always told me when we parted ways, hey kid, don't do anything I wouldn't do. And to that, when I part ways with my friends, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.